George. Good morning.
Your Honor, I tried this case in the Superior Court back in 2006, and of course was involved in the appeal of this case, so I'm not going to go through the facts. I also submitted a very extensive appendix because the limitations of the brief itself, I could not set forth all of the different things I needed to set forth in some of the arguments, so I attached them as an appendix and then summarized those arguments in the brief. But I'd like to concentrate, although not highlight, I'd like to concentrate on 2 or 3 of those arguments for purposes of arguing before you today. This case, which resulted in a conviction in November 2006, basically rested, in my opinion, on 2 particular pieces of evidence. One was the DNA evidence in the case, which allegedly...
Okay, why was that so important when the defendant, at least as I understand it, and I haven't read the transcripts, he admitted to having sexual intercourse with the deceased?
Well, the reason it was important, Your Honor, Justice Cowan, is because the defendant would have never been interviewed in the first place had there not been the DNA match. In other words, when he was being interviewed by the police at the...
Yes, but your claim is that he lacked the ability to confront as it was under laws developed in Melendez-Diaz. Okay, but you don't have any right to confront during an investigation. The police can get their material from any informant, I mean, as you well know, or any dirty source that they want, and there's no right to confront. So the DNA and the problems with the lack of the the person who did the test testifying at trial doesn't come into play during the investigation.
Well, see, the point of the matter is, Your Honor, is that the DNA test that we're talking about, which is the buccal swab of the defendant, which was taken in March of 2004 at his probation interview, and I know you probably read that it was taken at his probation interview at the Barnstable District Court, that the police were waiting for him there when he got there, and that swab was taken.
But didn't at trial, at least I thought I read this, you didn't object to that particular swab. It was the swabs from the decedent, the victim, right?
No, Your Honor. I objected. In this particular case, I don't believe I had to object. In this case, the buccal swabs from the defendant were the ones that the expert, Christine Lamry, the DNA analyst who testified, had not tested.
Yes, no, I understand that.
I did.
I thought maybe it was McCowen's brief. I read that there was a sidebar.
I understand the sidebar you're talking about, Your Honor. At that point, there was no reason to object because the law at the time allowed the testimony to come in.
But so I'm saying, how did that harm you? Because he said he had consensual sex with her.
The reason it harmed me, Your Honor, the position I'm taking is that there would have been the only 2 pieces of evidence in this case that connected the defendant to the crime were his statement, which you're mentioning right now, and before that, of course, you're saying that the DNA swab, which led to the interrogation taking place in the first place, because it was the DNA test that was not performed by this analyst.
But the test hadn't been performed when they took the swab. What I'm saying is the whole confrontation issue doesn't come up until there's a trial, so the taking of the DNA swab from his mouth has nothing to do with the right of confrontation.
But just because it still is inadmissible. The testing itself is inadmissible at trial.
But
the jury would have never heard it.
By the time it comes to trial, it's moot if he has admitted that he's had consensual sex with her.
Well, the position of the defendant is that we would not have had to cross-examine, we would have not had to face the issue of even being connected to the body if the DNA swab hadn't come in. It was the matching of the buccal swab to the original testing that was the connection that took place in this case.
Now, I'm just trying to make sure I understand. Ms. Lumley, I gather, was the analyst who actually examined the DNA that was taken from the body.
Yes, Your Honor.
And then there was also a buccal swab DNA, which is a known exemplar taken from him.
Yes, Your Honor.
And that apparently was examined by another analyst.
That's right.
And then Ms. Lumley on the stand took, I guess, the analysis of the alleles from her analysis and the analysis of the alleles from the other persons, analysts, and said they matched. Is that?
That's right, Judge.
Now, when she said that they matched, was there any objection by you at trial to the fact that she was saying that the alleles that she had analyzed matched the alleles that somebody else had analyzed?
There was no objection, Judge Gantz, because at the time, Verdi was the controlling law.
But Verdi's always been limited to firearm examination and to cocaine to drug analysis. I don't think we've ever applied the Verdi principles in general to DNA analysis or more complex lab analysis, have we?
Well, my position is that I'm entitled to the defendant is entitled to the more favorable standard of review in determining this. I mean, at this point, I argued in my brief that under either standard, objection or not, that this is not a harmless admission of evidence in the case. When Melendez-Diaz came down, Melendez-Diaz, as I don't have to tell you, deals with lab reports. I argue that DNA testing is analogous to the type of testing that's dealt with in Melendez-Diaz.
Did the chemist, Ms. Lemire, is that the name?
Lemire.
Did Ms. Lemire testify? Well, let me ask you this. What was the actual evidence that came in of the testing of the defendant's DNA?
Lemire testified that the buccal swabs taken from the defendant were tested by another.
Okay.
This all came out on cross-examination. And that the buccal swabs matched.
That's her opinion. That's her opinion.
That she actually was testifying as to facts, but in her opinion that they matched.
Right. So she can do that regardless of, you can cross-examine her on her opinion, but that's her opinion.
So our position is she was testifying to facts. She was putting in the results. She was putting in the results done by another, her name was Patrina Geiger, through another analyst, admitted it on cross-examination, and the fact is, Your Honor, I wouldn't have had to cross-examine in the first place if in fact the match was not testified to. And by the way, the testing that she did do, because the Commonwealth lays out in its brief that I was incorrect in saying that Lemire did not do the testing. She did not do the testing of the buccal swabs. She did the testing of the saliva found on the victim's body, as well as some seminal fluid found in the area of her vaginal area. That is what she testified to the match.
Right.
And the fact is, we argued that the DNA, the buccal swabs, should have only come in through Patrina Geiger, who, by the way, was not unavailable. She was not unavailable. She was just someone whose evidence was being put in through Christine Lemire. And by the way, the law changed. This court knows that the law changed after the McCowen case. Melendez-Diaz came down after that, and of course Vasquez has come down since. I did not object at the time because the law at the time.
But in both those cases, there were statutes which spoke of the admissibility. There's no statute that speaks of the admissibility of DNA testimony.
Well, in this particular case, Your Honor, this DNA test, these buccal swab results that came in through Patrina Geiger, I was through Lemire. When I cross-examined, when we went to sidebar, the sidebar that Justice Roderick is talking about, we were not talking about chain of custody. We were not talking about issues as to whether it was McCowen's or not. We were talking about whether or not some stipulation that I don't believe was ever read into the record at any time. Some stipulation was being formulated as to whether or not the buccal swab was in fact taken from McCowen. The match itself was testified to by Lemire.
And she had every right to testify to that. That's not a Melendez-Diaz problem. I looked at these two things, I compared them, and they were matched.
Well, Justice Gordy, our position is that she was putting the results of Geiger in. It wasn't so much an opinion as she was putting in the results, because she was reading from Geiger's results on the witness stand. Now, I'd like to move on because I don't have as much time as it's obviously a large brief, and it's got a lot of different issues involved in the brief. But I just wanted to talk to you about the removal of the juror, Rachel Huffman. At some point during deliberations, it was the fourth day of deliberations, there was an issue. And the reason I argue this is because I know Justice Cowan was on the panel that wrote the Gary case. And what happened is there was a situation where one of the jurors, a juror's boyfriend, was arrested. And without getting into the facts, because I understand the court will read the record and read the
We've read the brief, so we know what
So what happened was there was a hearing conducted, a voir dire hearing. All the jurors were brought in, and after an extensive hearing, it took almost an hour and a half, the juror was returned to the jury.
And your complaint is that the next day there wasn't another hearing after the taped telephone call, but my question to you would be, the judge had already made up his mind that he wasn't going to believe her because she lacked credibility as far as he was concerned. So what would the purpose be of a second hearing?
Justice Cohen, you of all people understand that under Connor, because you were a prosecutor in that office at the time, that under Commonwealth versus Connor, almost the same thing happened. What happened was a judge conducted a hearing, talked to other jurors, and I believe it was Justice Donahue at the time, but I'm not sure, that after a hearing, a juror was returned, a problem juror was returned to the jury deliberations. They reported a deadlock. And as the jurors continued to complain about this one juror, he brought the juror back in. It might have been the following day, it might have been 3 days later, because in Connor, they were complaining about that juror throughout the trial, as everybody knows. That juror was then removed, discharged in almost like the identical fashion that this juror was removed in this case. He was brought back in after being vetted, carefully vetted, where the other jurors were carefully vetted, returned, and then after a short argument was removed without any further hearing. My argument is in this case that what was required, and I did object and did move for a mistrial as a result of it, the only argument that took place in this case on the second day, which is after the deadlock was reported, 2 or 3 hours after the deadlock. In fact, it was the day after the deadlock. A Tui Rodriguez charge had already been read to this jury. This juror that was removed was in a deadlocked jury. Was the phone call. Was the phone call from the jail from the boyfriend. And I rest on the record in this case because the contents of that call are innocuous. The juror is not accused at any time during that phone call of engaging in any misconduct.
What's the reference to court TV?
What happened was, Your Honors, on the day before, during the voir dire the day before, there had been some news coverage of the arrest of the boyfriend. And as a result of it, Court TV, who was covering the trial, picked up the fact that the arrest had come to be and that there were hearings taking place. The reference to Court TV was a passing reference to the fact that her parents had seen it, or family members had seen it on TV, that her name or that her involvement in it was on television. The trouble with that position of the court, and the reason I wanted to talk about that, is because on the day before, 4 jurors admitted to watching coverage of the trial and the arrest on TV. Because during the voir dire, 4 jurors admitted to it. The jury foreman admitted.
They admitted to what?
They admitted
watching
to
coverage of the arrest, not the trial.
Well, that's the same coverage that Huffman was referring to, the removed juror was referring to. And they were all returned to the jury the day before. Now, under Connor, the court is very clear. I understand it was 1984, but it was very clear that more is required to remove a juror, a deliberating juror, let alone one in a deadlock, than just bringing them in and discharging them, because nothing had changed in the day between. Now, was the court in a position to determine, as a result, the circumstances under which the call was made, the circumstances surrounding the receipt of the call? Because in this case, please be aware that the juror did not make the call. The juror received the call while court officers were making arrangements for a sequestered jury so people could get their things. Though invited in the call to discuss deliberations by the boyfriend, the juror didn't discuss deliberations, didn't discuss what was going on in the trial, and when she had been voir dire the day before, said she could be fair and impartial, and she was pretty closely examined by the court. There wasn't...
Mr. George, the Commonwealth said she lied to the judge when she minimized her involvement with Hicks, and she lied when she said she could remain fair and impartial.
And I invite, Justice Marshall, I invite you to read, we had a hearing on this. And actually, in fact, the tape itself, which is the only changed circumstance, the tape itself is marked as an exhibit.
It seems to me, and again, we haven't read the transcripts, that this juror, at least the judge, took the juror's statements at the initial hearing to mean that she was he said she was separating from him. I didn't know whether he meant separation in a separation divorce sense or separation physical. But, and he, the judge, believed that he was being misled as to the closeness of their relationship. And then, so that he no longer found her credible and wouldn't believe anything she said. So what is the point of a hearing if he no longer would believe what she testified?
Well, that's the point, Your Honor. The point is
but
that...
he's entitled to disbelieve any witness. And if he says, now she pulled the wool over my eyes, yes, he may be wrong. His findings may not be supported by the evidence, and that's what we've got to see. But if he says, I don't believe this witness, then what is the point of him bringing her in to testify? He won't believe it.
As you know, Judge Conlon, under Tennyson and under Connor, you don't have to bring her in. I mean, I'm not saying that they had to bring in the juror. What I'm saying is that you have to conduct a hearing of some kind to determine the circumstances surrounding the discharge of a deliberating juror. I mean, Connor is very clear about the protocol to be followed. In Gary...
Did the judge listen to the taped telephone call?
We all listened to the taped telephone call, and we disagreed on what it all meant or what was to be taken from it.
So how can he find out what it meant other than by asking her? And he's already made up his mind. He's not going to believe her.
Well, the circumstances under which the call was received and made, I mean, this end of the phone call, meaning the receipt end of the phone call, was something that took place in a jury setting with all kinds of witnesses. And another thing is that all the other jurors were present when the call was received. And in fact, I mean, what I'm saying is under Connor, the standards of conducting a hearing have been set forth very clearly. The judge relied on Gary. He found that there was a palpable conflict based upon the things that you just said, that she had minimized the depth of her relationship. In the tape recording, and you will see discussion of it, but it's also part of the record. In the tape recording, there was discussion about having raised a $3,000 legal fee for an attorney. That is the only discussion on the tape about whether or not there was a relationship. The judge found, as you've already said, and this is a deferential review as to the judge's right to find what he believes. I'm saying he was wrong. But in this particular case, that was the part about the relationship. He also found that she had lied about media coverage, that, her exposure to media coverage. Well, that all occurred the day before. And all four jurors, including this particular deliberating juror, the removed juror, was returned to the jury pool. So, I mean, nothing had changed in between. So what I'm saying is that the procedural requirements which were set forth not only in Connor, but also talked about in Gary, did not take place, which leads us to the next issue regarding the jury.
Before you leave that issue, I'm a little bit confused. After you were in the judge's lobby and listening to the tape, which I gather was not on the record, whatever was said in the lobby was not in the record, is that correct?
No, what is said is in the open court. No, the lobby conference is not on the record.
It's not on the record. Then you went back to open court, and then did he give you a chance to be heard, to argue as to whether or not she should be removed?
Well, basically, anybody here who knows me knows that, in reading the record, knows that I argued against the removal of the juror. But when we came back out into court, the Commonwealth moved to remove her. I argued against removing her, and that was the hearing.
So what hearing are you saying should have been held? An evidentiary hearing in which Ms. Huffman was...
Under Your Honor, under Connor, under Haywood, and under Gary and Tennyson, the standards for such a hearing are set forth pretty clearly. You have to have
specifically, what do you say was missing here? Because he did listen to a tape, but that's evidence, and he did give you a chance to be heard. So what did he not do?
The Commonwealth argues that had the juror been brought into, meaning the removed juror brought in, she has a right to take the Fifth Amendment. She has a right not to speak. But the other jurors should have been brought in for a voir dire. And I'm talking about a second voir dire, not the first voir dire, because the JV...
But if the... Yeah, well, I mean...
Well, what Judge Gantz has asked me, Judge Blatchford, is what type of hearing should be taking place. What you're doing is you're trying to ask...
But why bring in the other jurors if the issue is whether she lied to the judge the day before?
Because what she said on this end of the phone call, and I understand there's a tape recording, but the circumstances under which the call is received, the circumstances under her reaction upon receiving the call, the circumstances about what she said...
But the judge is not going to believe her. He's already made that determination. In his head, he says, I don't find her credible. So it doesn't matter what she says.
But Judge Conn, what I'm saying is he was wrong.
Oh, okay, all right.
We agree on that I say he's wrong.
So that's...
But I try not to argue the judges that...
Okay, but what you're saying basically is...
Say so.
if we examine the tape recording, we will not find sufficient evidence to support the finding that she lied.
Yes, and that's,
Or,
yes.
or are you
Yes.
saying that he shouldn't have made up his mind without hearing from her again?
I'm saying that as well, but I want you to know, Judge Wadsworth, that I also know that in the same cases that I'm citing to you in support of what I'm arguing, that they say that the juror doesn't have to be brought back. And I think it might be Gary that says that the juror does not have to be brought back to conduct another hearing, but that another hearing should be conducted in which the circumstances surrounding the event that's being considered that would lead to discharge is being fully fleshed out on the record before such a momentous act takes place. Which leads us into Huffman's, as we've been talking about for the last 5 minutes, about Huffman's incredibility. In this particular case, we had 4 days of post-trial hearings in which a woman named Rosina Bohanna, we had 3 jurors talking about the actions of 3 other jurors. We're talking about 6 jurors involved in the evidence, in which all, according to the case law that I read and the case law we were operating under at the time and still are, is that under Laguerre and the other case authority on issue, that all you have to raise is that that what is alleged in the affidavits giving rise to the hearing in the first place are generally true by a preponderance of the evidence. In this case, we had 5 days of hearings in which jurors testified consistently with their affidavits, and I note in the Commonwealth's brief when they argue this, they don't mention that the main and first complaining juror, Rosina Bohanna, who everyone was, which actually brought the hearing into being in the first place, is not even discussed. I mean, in this case, we had affidavits filed, whether they were through draftsmanship or not. They were all done by the jurors. They all testified in a very unique and extraordinary, 4-day hearing. That you have the record in which they testified. They testified consistently with their affidavits and generally corroborated one another as to what events took place in the jury room. Our argument is that those satisfy the standards set forth in Laguerre for a new trial. And the reason I'm going faster now is I see the red light flashing.
Actually, that means your time is up.
I'd like to say thank you.
Thank you, Mr. George.
I just didn't want to stop until you told me to.
Fine. That happens many times, yeah. Good morning, Ms. Holler.
Good morning, Your Honor. May it please the Court, Julia Holler on behalf of the Commonwealth.
It would help me, Ms. Holler. I'm sure other people have other questions too. But there are 3 points brought up in Mr. George's reply brief that if you could explain these 3, it would help me a lot. The first is, what do you say about the fact that the defendant says, and I checked the transcript and he's accurate, that Dr. Niels, I wouldn't expect otherwise, but I did check the transcript, Dr. Niels testified to findings that were important at the time of death, as contained in Dr. Weiner's notes, and according to the defendant, that he relayed Dr. Weiner's findings to postulate a rape theory.
Yes, those 2, and if you've read my brief, I do concede that there were a couple of points on direct, and one of them is the time of death, and the other is the rape. However, if you look at the cross-examination of Dr. Niels...
Yeah, I read that you said that that's important to the defense.
Right. The defense spends a great deal of time questioning Dr. Niels about Dr. Weiner's presence and what he saw at the crime scene, because he spends a lot of time discussing what were the factors of rigor. Did you see rigor? And then the question of how the presence of rigor relates to the time of death. And through Dr. Weiner's notes about what he saw at the crime scene, the defendant uses this to try and get Dr. Niels to say that the time of death is actually later than when the defendant's statement says that he had sex with the victim and the night the victim was killed. So it's very integral to the defendant's cross-examination and his case as to time of death. He takes what was essentially just related by Dr. Niels and expounds upon this.
Okay, what about the suggestions of a rape?
Again, it's the same situation. He spends, and I can give you it's transcript pages 1269 through 1270, talks about, there's a handwritten note by Weiner's, the only thing that can be considered a sign of sexual trauma. It's an indication there's a small amount of blood in the victim's vagina at the scene. then the defense counsel goes on to say that there were some streaks of blood across the lower chest or abdomen, but it's possible that the child put those there. Then counsel also in cross brings out that Weiner's report does not mention any tearing, bruising, contusions of the vaginal area, or any trauma to the genitalia. That's 1271 to 1272. And then counsel brings out that there is no...
But that isn't helpful to the defense. That just seems that he's trying to get back at what you put in on direct.
No, he's trying to use it to show that there were no signs. Dr. Weiner found no signs of a forced sexual encounter.
As Justice Kahn suggests, that's because there's testimony, evidence that it was a rape.
It's not... I lost my train of thought, sorry. Okay, there's the only thing that is mentioned on direct is, and this is at page 1231, Weiner's handwritten notes describe a small amount of blood in the vagina, and then it's depicted on the diagram, and that's the only mention. It's not linked with any evidence of sexual trauma or any...
But does then Dr. Niels opine that there was a rape based on that?
I don't believe he does. Defense counsel...
Okay, is there any connection between the fact that there was a small amount of blood in the vagina and that is in any way an indication of forcible sexual intercourse?
I don't believe there is, no. I have to look back. But defense counsel takes that and extrapolates it the other way to show that there was no forceful rape and discuss it, and even gets, and Dr. Niels even says that you, at one point, I guess during redirect, says you don't often find that there is signs of forcible. That comes in on redirect. That may be where you're seeing that, Your Honor.
Okay, and then my last question is that the defense argues that the information about that other man, Fraser, that there was information in your office about his arrest for A and B DW in a night, whereas your brief, as I recall, states that all this information was in another district attorney's office, not in your office.
Not in another district attorney's office. This was there's no indication. It was a case that was dismissed by our office back in 2002 because the two alleged victims did not appear. And at that point, it was dismissed. My point on that also, Your Honor, is that counsel claims that this is newly discovered and things that were withheld. But if you look at the sidebar, and give me one moment. At page 2124 through 2127, it's during the cross-examination of Jeremy Fraser. And defense counsel starts to try and get into the charges that Fraser was arrested for. There's a sidebar and the Commonwealth's objection. It's clear from the context that the defense counsel has Jeremy Fraser's record in his hand, and that he is saying, I'm not going to get into the facts of the arrests. He says, I'm using this to show that these charges...
Why is it clear that he has the records in his hand?
Because you can, from the context of the sidebar, defense counsel says, he's aware of the arrest. I'm not going to get into the context of the arrest. He says, I'm not going to get into the facts of the arrests.
So?
He says, I just want to be able to take these arrests and show that they were all dismissed. It shows that counsel was aware. He's claiming that this was newly discovered. He didn't have access to this. And that we had...
You're saying because he knew that there was an arrest and he knew it had been dismissed.
He knew it was arrested and dismissed. He knew where to find it. It was not anything that was withheld by the Commonwealth. It was part of his defense.
Wait a minute. They're two different things. Was it produced by the Commonwealth?
The records?
Yes.
No.
But if he's got them, that's quite irrelevant.
If he had the Corey, which leads him to say there was an arrest for an assault with a dangerous weapon, apparently. I'm not sure, but it's on there. It says that it was dismissed. Now, he's got this sheet, but his point, and when you read it, he's now taken another tact on appeal. It was not to show that this was a prior bad act or a similar conduct. That was not the intent. The intent was to attempt to show that Jeremy Frazier had these charges and that for some reason they all kept getting dismissed and that therefore he was somehow the darling of the prosecution or the police down there, and the police kept getting him out of trouble. That was the whole tack taken by the defense. It was not ever going to be used to show that there was some sort of an incident. It doesn't come through from this sidebar that it was ever going to be used to show an incident of a similar fact as related. And the judge in his findings finds that the incidents were not using even if you use the newly discovered evidence, the judge in his findings finds that they were not similarly related, that pulling a small pocket knife is certainly not the same as stabbing a woman through the chest so hard that it goes through the chest and comes out the back during a breaking and entering in a rape.
And my last question is, what do you say about the judge's findings or lack thereof as to the witness Roshina Bahana?
When you read the judge's findings, Roshina Bahana's testimony is woven throughout, and her testimony is talked about throughout the whole facts. When you read the testimony of the Juror Cahill incident, which is in the record at 218, the judge's findings, it talks a great deal about Bohanna's affidavit, talking about linking. Juror Cahill was the one who said that the defendant was staring at her and she was upset by that. And the judge specifically makes a finding that Bohanna links the two of the fear and the defendant's race, but then that was in the affidavit, but then when Bohanna testifies, she doesn't make that link, so the judge says, well, I find her credible at the hearing rather than than in her affidavit. Then also, if you go to the Juror George incident, which is when this big black man beats on a small white woman, that whole episode, again, Juror Bohanna's is linked inside that, and at page, even at 222, 221 through 222, the judge relates his findings, that's in the record, as to the reactions of Bohanna and the fact that she and Juror Cahill were swearing at each other, and that it broke up, and then that one of them might have apologized, and that they were then talking to each other and were civil again. Bohanna's testimony and her findings are woven throughout all of these incidents. The judge does not discard them. He does not ignore them. He puts them in the context of the other incidents. He puts all of them within the context of each of the incidents. He specifically deals with when you read it, he explains why he doesn't accept the affidavits. He accepts Juror Bohanna, and he uses her testimony. The judge writes why he does not accept.
Well, he doesn't say he doesn't accept the affidavits. What he's really saying is, to the extent that there's inconsistency.
It's not an acceptance.
I mean, he never says
No.
They lied.
No, that's a poor choice of word. I apologize for that.
It seemed to me he was very careful.
Yes.
And I think that he was saying, these were drafted by a lawyer, and I don't think the lawyer was being, I forget the word that he used, I can't find it, but, the lawyer was not misleading. It's just somebody summarizing and what the judge was doing.
It's not our claim that this is certainly not our claim that these were somehow engineered.
No, it's
not
just
at all.
He was teasing out, and what he was really doing was trying to figure out exactly who said what.
Right.
That's what he was trying to do.
He gives his reasons when he says that I don't find this part of one of the affidavits credible. He takes the time to explain out why he doesn't find that credible. And that's why he does not specifically list Juror Bohanna, because he says that, yes, in the context of the way her affidavit is phrased, it does come in, but it's woven throughout all of the other instances.
During jury selection, was there any request, or did the judge speak to the jury about racial bias? Was there any statement that...
Oh, absolutely.
Absolutely.
So that was addressed during voir dire?
Absolutely.
It was very specific.
Absolutely. And it was certainly a situation where you had the need for an individual voir dire as well because of the interracial nature of the case. There were even questions. The judge invited questions, and among the three, they came up with questions to ask each juror involving race, involving whether a juror would believe that confessions can be false, things like that.
What do you mean among the three? Oh, the judge
The
and
judge
the
and
two lawyers. Oh,
the two lawyers, yes.
And the Commonwealth moved to strike Bohanna, correct?
The Commonwealth moved to strike Gomes.
Oh, I'm sorry,
Not
Gomes.
Gomes.
I'm
not
sorry.
Bohanna.
That's
Moved to
correct.
strike Gomes because of the fact that he had had a prior criminal episode.
I'm sorry.
Right, not Juror Bohanna.
Going back to Frazier, there was some reference, I thought, in the briefs to Frazier testifying at trial that he had no criminal record. Did he say that at trial?
No, he doesn't say that at trial. What happens is the defense attorney asks him if he's ever been prosecuted, and Frazier says no, and then immediately says, what does prosecuted mean? And when you read Frazier's testimony, he's very upfront when he says, yes, I've been arrested, yes, I've had these problems. It's more a question of he didn't know what prosecuted meant when he said no. If you look at, that's at page 2133. He says, the defendant hasn't, he says, I haven't been prosecuted. What does prosecuted mean? And then he says, I don't know how many times I've been arrested. He's been arrested. He says, I've been arrested 3 or 4 times. Some of the charges were dropped, and he didn't really know his record. And that's at, I think, pages 2122 through 2124.
Okay, so even if the defense counsel didn't have Frazier's record in hand, he had Frazier's testimony at trial saying, I've been arrested 3 or 4 times, I don't know how many, and some of the charges have been dropped, i.e. dismissed or something.
Right. So it was, and again, it was not being used for the purposes of a prior bad acts, or not a prior bad acts, but a similar crimes, or he could have done it in the other extent. And Frazier, I think at that same sidebar, the prosecutor remarks that we're certainly not dealing with a learned hand here as a witness. And that actually is said in the transcript that this guy is just not, the brightest person that you might encounter in the day-to-day life.
The information about the restraining orders,
Yes.
that comes in because there's a question by Mr. George of the arresting officer as to why he arrested, and that is viewed as having opened the door to allowing in the other evidence
When
about...
you read the context of how that comes in, defense counsel, during the cross-examination of the trooper, which was voluminous, this was the major trooper, basically leaves the jury with the impression that the only reason why the defendant was arrested was because he lied to them when he said he had no contact. And then they now have this DNA report that says that it's his DNA on the victim.
Why isn't that enough? I mean, why do you need,
Well, it leaves the jury with the impression, in hindsight perhaps, it could be enough, but there were other things. And that that was not the only reason why he was arrested. It's a distortion of the trooper's testimony. Then on redirect,
because there were warrants out?
no warrants, no.
Well, then, you mean he got arrested because in the past
He had prior convictions. He had prior convictions. Not convictions, but restraining orders against
That would be
4
a
of
reason
them.
to arrest him?
No, that was part of the reason as to why they made, in the arrest warrant, the reasons that they put in the arrest warrant. The defendant leaves during cross-examination with the impression that tries to, that the only reason why the defendant was arrested is because he lied to the trooper. That's the way the defendant comes out on cross-examination. Now, that's not why he was arrested. The arrest warrant has that, has the DNA, and also has the evidence that he had a history of violence against women.
But, I mean, to me, that is so prejudicial.
Well, it was it was open the doors, part of it. It was not offered to prove that he was a bad person. It was proof to the other extent. And the judge gives an extremely precise and strong limiting instruction at the end of it. And actually, it is at pages 2082 and 2083, and the judge's instruction is at 2083 and 2084. He gives a very, very strong limiting instruction on that it cannot be used for such a thing.
Were the temporary restraining orders against one person or against several people?
There were 5 restraining orders against 5 different women.
With whom are these people with whom he lived, or?
I don't believe it comes out in the record. It just says that there had been, and there was just part of it was the evidence of those restraining orders.
And was that argued in closing?
I don't believe it was, Your Honor.
And do you think that was a proper balancing of the risk of prejudice versus probative value?
Certainly, when it was the defense attorney who leaves the jury with the misimpression that the police, which was all part of the, he's a black garbage man, this is why he was arrested, which is the whole theme of the defense from opening argument.
But you said one of the other reasons, which seems to me to be pretty strong, is that they have the DNA evidence.
Right. But they had it was part of it. They had the DNA, they had it, and this was just another part of it. But the way the cross-examination comes out, when you read that cross-examination, the cross-examination comes out, you've got this, it doesn't talk about the DNA, it just says he was arrested because he lied to the trooper when on 2 previous occasions.
No, what I'm saying to you is that if you need to meet that problem, the arrest warrant, as you've described it to us, has as a reason for the arrest, in addition to the lying, the fact that the DNA matched what was found in the victim's body.
Right. But this was not, it's the Commonwealth's position that this was not something that was excludable. Perhaps in looking at it, you look at it, but it was clearly not admissible for prior bad acts, and it was clearly used to get rid of this misimpression, and the judge strongly argued that. And it doesn't appear that I don't believe it was mentioned in closing. The closings are both very long and not my mind, but I can say with some confidence I don't believe it was mentioned in closing. And just to wrap up one point, if I may, because I'm almost out of time, I see that is, as far as the Lemire, as to the DNA testimony, the defendant's failure to object is certainly not just an acquiescence. As he may say, Crawford had come out by this point. By the time this trial, we had Crawford. If you look at that sidebar, which is at 2522 through 2524, the prosecutor, they go to sidebar and he says, we're getting into chain of custody. I thought there was a stipulation. Defense counsel says that it's an attack on the integrity of how items were kept. It's not a chain of custody and this is of the defendant's sample, the defendant's DNA samples only, as to whether they were properly processed, and that, yes, this is the defendant's DNA sample. And at the end of this sidebar, the judge says, if you have an agreement, then you're not going to be able to go into whether this is the defendant's or somebody else's DNA. And defense counsel says that he has no trouble, and I have that in quotes, so I believe that is an actual quote, he has no trouble stipulating that the buccal swab Lemire is testifying to is the defendant's. So it's not a question of whether or not we needed this other person to come in and testify. The defendant stipulates, this is my DNA.
Right, but his argument is not that it was not his DNA. His argument is as to whether or not the allele analysis was correct.
Which was done by the DNA analyst who testified. That was done by the
I thought that I thought all she did was compare the alleles that she did with the alleles that were found as a result of the other analyst's analysis.
No.
She compared paper.
She did all of the evidentiary standards. She did all of the submitted samples except for the defendant's. This other analyst tested the defendant's sample and made this profile of the defendant. And then it was Lemire who did the comparisons.
But
she's using the defendant's sample, which the defendant has stipulated that these are mine. That's what the defendant says.
He stipulated that the DNA was his. He hasn't necessarily stipulated that the analysis of the alleles was accurate.
Well, the analysis, I believe, was done by Lemire, not by this. I guess I'm getting
confused. Comparing about it's one thing to say I can take two. I can take two analysts and say it's A here, it's A here, it's B here, it's B here. That can be done, but the question is whether it was A, B, what the analysis was. That was done by somebody else.
The question of what the defendant's A's and B's and C's were was done by another one. Then Lemire took that, and the defendant is saying, I'm not disputing that this is the defendant's DNA profile. That's what he says. I'm not disputing that.
But isn't that rendered harmless anyway by the fact that the defense was that, yes, this is my DNA. I had consensual sex with her. I'm not surprised that my DNA was found on her body.
Right. I mean, you're right, but it's just in addressing these issues with this argument. Right. It is kind of rendered moot by it. And if there are no further questions, I will submit on my brief.
Thank you, Ms.
Thank you.